punished without given the chance of telling your side of the story. No explanation, no evidences, but just a decision which came against you. This is where the principles of natural justice comes into the light, to provide the decision in the transparent manner with the fairness and non-arbitrariness. So, in this video, we will discuss about the principles of natural justice in certain stages. First, we will know about the principles of natural justice and its evolution. Secondly, we will know about the three golden principles of natural justice. And thirdly, we will know about its applicability and certain landmark judgments in which we can see the involvement of principles of natural justice for the fair decision making. So first we will know about the principles of natural justice and its evolution. As I use the terms now for the principles of natural justice, which are the fairness, transparency, and the non-arbitrary nature of any judgment. So the principles of natural justice basically tries to ensure that there is fairness in the decision making, and its evolution can be traced back to the late 18th century in the English law system, and its traces can also be seen in the Indian judiciary, which was basically known as Dharma in the ancient time. So the principles of natural justice are also traced in the Kautilya's Arthashastra, which was basically a book which outlined the principles or the laws to be practiced by the judge or by the council of ministers while adjudicating any case, any disputes or conflicts between the parties, between the people of the kingdom. The principles of natural justice ensures that there is a fair hearing opportunity given to the parties in the case. There is no biasness in the case, and there is a reason behind every judgment or decision given by the person in authority. Now we will understand about three golden principles of natural justice one by one. So the first principle of natural justice is Nemo, judex in causa sua. It is a Latin maxim as it evolved through the UK legal system. So we can see that the legal maxim which was used was Nemo, judex in causa sua, which literally translates to no one should be a judge in his own cause. So it ensures that there is no biasness by the judge being involved himself in the cause of the case. It ensures that there is no biasness practiced by the judge while giving the decision in the case. So these biasness can be categorized in certain categories, which we can discuss it as a types of biasness which can be practiced by the judge. So there are three kinds of biasness which we will discuss. First one is personal biasness, second one is pecuniary or monetary biasness, third one is subject matter biasness. So the personal biasness refers to the biasness in which the judge is related to either of the party, being the relative or friend or somehow related in the course of the business. So in such a situation, the decision of the judge can be biased towards the party with whom he is related in such a nature. Second one is pecuniary or monetary biasness. It is such a biasness in which the judge is somehow getting benefited in the nature of money. So it can be either that the compensation will be given to the judge if such a decision is given by the judge in favor of the party, who will be later giving the monetary benefit to the judge. Such a biasness is known as pecuniary biasness. Third biasness is subject matter biasness. It refers to the biasness in which the general interest of the judge is involved in the case, and later he will be benefited if the decision comes into the favor of either of the party. So these are certain kinds of biasness which can be practiced by the judge while giving the judgment. Now we will come to the second golden principle of natural justice, which is for the fair hearing. The Latin maxim to it is audi-ialterem partem, which says that either party or both the parties should be heard in the case. So it says that there shall be fair trial, there shall be fair hearing, and the prior notice shall be given to both the parties to be able to present their arguments, evidences, and to make the cross examination towards the evidences presented by both the parties. So this is known as the principle of audi-ialterem partem, that is where both the parties are given the opportunity to make their stories into the light and to present their arguments in the particular case, to present the witnesses, evidences, and to make cross examination towards each other. The third golden principle of natural justice is reasoned decisions, for which the Latin maxim is ratio decidendi, ratio decidendi, which refers to the rationale of the decision, that is the reasoned decisions. So while the judge gives any decision in the case, there shall be prior reasons, or there shall be written decisions which shall be expressed by the judge after giving such a judgment or making such a decision. So all these principles of natural justice ensures that there is fairness, transparency, and non-arbitrariness in the decision making, and it is fair in its nature. Now next we will discuss about how it is applied in today's scenario. So it is not just that the principles of natural justice applied by the judges in the cases which are made towards them, but it is also practiced in the corporate businesses where the employees are involved. So assume a situation in which employee is given just a ultimatum that he is removed from his position, and from tomorrow he don't have to come to the job, without given prior notice for his removal or given the chance to be heard for the reason for his removal, etc. So in such a situation, there is a violation of the principles of natural justice, and such an employee can proceed towards the judge in the form of the complaint towards such a company for giving a removal on the spot without giving the notice or the opportunity for giving the arguments or reasons for any such conduct for which the company is removing such an employee. So in such a situation also the principles of natural justice are applied. So next we will proceed with the exceptions to the principles of natural justice, where there is an exemption where the judges are given, the judges or even the government can adjudicate the case or make the decision in any case without giving the opportunity of natural justice. So there are certain situations in which a judge or a government can do such an act without giving the opportunity of principles of natural justice. First of it is in the situation of emergency. So in a situation of emergency, assume there is a situation in which there is an increased internal aggression in a state or a country, and where there is no scope to give the opportunity of fair hearing or presenting the arguments, evidences by each of the person who is involved in creating the internal aggression. So in such a situation, the principles of natural justice are given an exemption. Second situation is where the legislature or a statute itself exempts the fair hearing principle or giving the reason behind making such a decision. So in such a situation also the principles of natural justice are exempted. So these are some of the situations where the principles of natural justice are given the exemption. Through this video we can conclude that the principles of natural justice basically says that hear fairly, decide impartially, and explain clearly. So if there is any conflict in any administrative matter, in any torts case, criminal case, civil case, or any corporate job or employee and labor union conflict, there also the situation and the principles of natural justice will apply, where it will ensure that there is a fairness in decision making. Thank you for watching the video, and if there is any doubt regarding the principles of natural justice, comment below in the comment section and I will answer to all your doubts.